You want to continue to interrupt me, aren't you?
No, sir. I'm sorry.
The rules never, decorum, the rules of law, none of this follow you. 22-39941, Roderick Lane Wynn. Is that you?
Correct.
Present with Mr. Smith, your attorney and the state's attorney. Earlier, you pleaded guilty to operating a motor vehicle in a public place while intoxicated, and paragraph 2 represented in the indictment reflects that you have 2 or more prior convictions of DWIs. So paragraphs 1 and 2 constitute a third degree felony. And the agreement is whatever sentence shall not exceed a cap of 8 years in prison. So you're looking at no less than 2 nor more than 8 years in prison. Or I guess deferred or unadjudicated probation is possible.
Yes, sir.
That's about it for
That's about
options.
No. Deferred, it's not,
Well, I guess deferred's not.
no, it's not available, no, sir.
Deferred or regular, one of them is not.
Deferred.
Deferred is not.
Okay, regular probation is allowed.
Yes, sir.
So you're looking at no less than 2 nor more than 8 years confinement in prison, and that could be probated, and you could be placed on probation. You understand?
Yes, sir.
But you get convicted with these types of offenses, you don't get a deferred probation. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Any corrections or changes to it?
Yes, sir. We've reviewed it. We have no correction.
Nothing from the state, Judge.
It's made a part of the record for all purposes. All right, go ahead.
Your Honor, we would ask the court to take judicial knowledge of the fact that we have submitted, last week, we submitted character letters for Mr. Wynn, and family and friend. They were submitted to the court, and they all talk about how he is a good man, very involved with the church, and that he's a professional painter, and that he is the primary caretaker for his 85-year-old mother. And she even wrote you a letter as well. So we're asking the court to take all of those letters into consideration. On the PSI report, looking at his criminal history.
Wait. What did the mother say?
Your Honor, this is what you want to read it, or
No. I think I've got it here. I just summarized it.
She wrote a letter to the court stating that, talking, of course, very, very nice things about her son, but it's cooperated by the other letters. He is a very has a good heart and helps other people that are needing his help. He works construction and a professional painter. And he's always giving a helping hand to other people. And the mother, told the court, which is very, very important. He is her primary caretaker, and that he lives with his mother, and he is the one. He is the one who takes her to her. What kind of is she? He is the one who takes her to the dialysis. In between him working on a full-time basis, and so she was asking the court, to take all that into consideration in the court's decision as to what is the proper sentence in this case. And in addition to that, his criminal history shows back in 1996, when he was like 19 or 20, he was placed on probation for a criminally negligent homicide. That case did not involve alcohol and involved him racing. And there was a wreck as a result of the racing, and his best friend, they had a wreck, and ultimately the best friend was killed as a result of that wreck. He was placed on probation in 1997. However, it was revoked and he ended up doing 1 year in state jail back in 1998. The only other,
Do you have a copy of that prior conviction in your file by any chance?
I might, Judge. Yes, you do. Sorry, I'm playing
Go
catch up
ahead.
here.
Go to the federal court conviction.
yes, you are. In 2002, he pled guilty, was sentenced to 12 months imprisonment, and 36 months supervised release. That supervised release was revoked in January of 2006. My client does not remember doing anything. He does not remember what the violation was. He does know that he had been on supervised release for a while, and he was interested in getting off of supervised release. And he ended up, in fact, getting the supervised release revoked and serving only 6 months, and then it was over with. Since that time, when he got out, the only criminal problems that he has had are the 2 prior DWIs. One in 22, one in 2012, and the other one is in 2014. And there was in 2012 a possession of marijuana, but that case was dismissed. I'm sure it was dismissed as a result of taking 30 days in jail on the 2012 DWI. This is a 49-year-old man. He lives here. He works hard. The report prepared by the probation department points out that if the court is inclined to award probation on this, my client, they recommend that, of course, he do successfully complete the JCDI program, which he is quite anxious to do. He wants to put this alcohol problem behind him, and whatever rules and regulations regarding the treatment of the alcohol, which he has not had in the past, he is very anxious, to do that. And so, because of that, Judge, we're asking the court to give him an opportunity to prove the court that he can get control of his alcohol. We're only here because of his alcohol, and for continue to have a full-time job and to fully take care of his mother. So that's what we're asking the court to do. Is there anything that you would like to address the court?
Sir, Judge, I understand the situation. I pretty much want to take care of my business and do probation. You know, usually say, one by 85 shit on the altitude, I go there every day. But if you go Monday to Tuesday, it comes Fridays. And I really need to get back with her, so if you don't mind. And I can guarantee you won't see me again back in that club and drinking.
Well, if I was a betting man, I'd bet against that. Because of the pre-sentence report. What I know about you that's been admitted into evidence here.
Guarantee you I would not.
You would guarantee me.
Yes, sir, I will.
You're being absolutely truthful with me.
Truthful.
State, hold on. I'm just going to ask you a couple of questions. And I'm going to ask the state.
My turn, Judge, or you
I'm
have a
not just
question?
asking for a second.
Yes, sir. I want to make sure I understood.
To you because you may want to take a little bit of time.
Thank you, Judge.
How many prior convictions do you have for adult misdemeanor cases in county courts at law? Let's start off with that. How many?
Two that I know.
Sir?
Two that I know.
6. How many adult felony cases do you have in the felony courts here? Got one. And how many federal felony cases, convictions do you have?
One.
That's felon in possession of a firearm. What about these cases that really tell me all about your criminal history for drinking problems, like Mr. Smith said? These would be these Class C misdemeanors, traffic citations, um, like failures to appear, bad checks, alcohol in vehicles, false reports of public servants, yeah, the Class C misdemeanors that obviously involve issues that probably are related to your drinking problems. How many convictions do you have? You know best, not me. You know best. It's your life. Look me in the eye and tell me and see how close you are to the right answer. How many?
About 8.
50. There they are, right there, buddy. Your life, the pre-sentence report that just got admitted. Look at all those yellows. Look at it. Read them to me. You want me to read them to you? You're going to look me in the eye and say you're going to be straight with me,
Yes,
and you
sir.
say 8 when there's 50. You have 29 traffic citations, offense citations, 8 failures to appear citations, 6 bad check citations, 2 alcohol open container citations, 2 theft by check citations, 2 city ordinance citations, 1 false report. I mean, that adds up to 50. Plus, you've got back to 96, illegal possession of marijuana conviction, failure to identify conviction, family assault conviction. Family assault, my goodness, you're talking about your family is concerned. You got a family assault conviction, evading detention, driving while intoxicated, illegal possession, driving while intoxicated a second time, then criminal negligent homicide. Criminal negligent homicide and illegal possession of a firearm by a felon in federal court. I'm going to rail on a little bit on the criminal negligent homicide. But Mr. Smith said, terrible situation. What was it, your best friend? Your best friend. So you are charged with killing, being responsible for the death of your best friend. So you were placed on probation. And how long did that last before it was revoked? A little over a year. And then it was revoked by another judge. Your best friend, I guess that was a terrible loss to you and his family. In that case, you were ordered to pay restitution in the amount of, let's see, where is that? You were ordered to pay restitution, that is to the loss of the family, to that poor man, in the amount of, let me see, where is this? $4,748.16 when you were placed on probation. You were revoked a year later. What were you revoked for? Do you remember? Because I can tell you. You were revoked by the judge for failing to serve 300 hours of community service and failing to submit to a substance abuse assessment and follow the recommended treatment program. You didn't even care to help yourself. So the judge revoked you, sentenced you, and here's what's interesting. This Judge Giblin, after all of that was over with, he sentenced you, and included in the sentence is restitution ordered in the amount of $4,748.16. You never paid for your best friend's loss 1 penny.
Sure.
1 penny you never paid back. Dude, but you want to stand behind him and show remorse and try to make me feel guilty that it was your best friend that you were responsible for killing? You didn't pay 1 penny to that man's loss that you were ordered to. That's how much you think of your best friend, but you certainly want to stand behind him now.
Sir, I did.
We have a total here of 58 convictions, and you're asking for 58 convictions. Don't look like you don't, like, I can't believe it's not butter.
I understand.
58 convictions, and now you're fine, and
I
you
was
want to
young.
do the right thing now?
I was young.
Okay, you were young. You're here before me. You were here before me with something that happened January 31st, 2022. What was your blood alcohol? 2.42. 242. 3 times the legal limit. Mr. I'm sorry for drinking. After all of this, 56 convictions, you're still operating motor vehicles high as a kite, 4,000-pound missiles. Something you were placed on, a person was killed before because of this.
No, sir. I wasn't even drinking then.
You were charged with negligent homicide, right?
No.
But you were responsible for a person's death.
I was negligent for rape.
You were responsible for your best friend's death, right? All right. Whether it was or not, it's one mistake after another. Oh, all
No,
right.
I
I'm
get-
railing on. And let me see what the state has to say.
Judge, you highlighted first my
Here.
biggest concern about
Here's the
the
fire.
blood alcohol content. There are a couple of items out of the police report that aren't included in the pre-sentence investigation report. Mr. Nguyen refused to take any tests, and he told the police department that they were petty for just stopping him. I'll remind you that here, they were checking on this man's welfare because he was asleep in the car there at Lamar. When they pull him out, this man was so unaware of his circumstances that he had urinated on himself. And I highlight those things because I think there's a lapse between the reality and his perception. The comment today is that that he wants some
Here.
kind of leniency here,
Sorry.
that he's hoping for some kind of probation. Your Honor, when we look at his version, he says he was intoxicated after leaving the bachelor party for his friend. If we go to page 4 of the report, we go down to the 5th line, the end of that 5th line. The defendant reported he drank for 3 days straight for a bachelor party, but there is no problem with his drinking. My comment has to be that maybe he's referring to he's got no problem, he's going to keep drinking.
And
And that's
that's the legal limit speaks for itself.
He has a 36-year history of alcohol use. He's the 2 probations or types of probations where he gave the government an opportunity to supervise him. He revoked in 96. He revoked a similar opportunity when he was a felon in possession of a firearm in 2006 with the feds. Probation in this circumstance is highly unwarranted. Your Honor, I would ask that you assess him a term of 8 years.
Your Honor, if I may,
Yeah.
again, I would,
Show me something good.
well, Judge.
I can't-
this
I'm looking
man,
at this. This
he
is
suffering
terrible.
from a severe illness, and that is alcoholism, and that is the reason why we are here. That is the reason why he had his other 2 priors.
Let me see that again.
DWI.
I'm going to repeat
Or
what
where
happened
he
earlier.
refused.
A long time ago on his felony conviction. He was revoked for, among other things, by Judge Gibson, for pleading true. What did he plead true? It's poignant here for this. He pleaded true to failing to submit to a substance abuse assessment and follow the recommended treatment plan. And that was back in years ago.
Yeah, he was 19 or 20 at the time, and as we all know, an alcoholic, a lot of times when they're young, they do not accept the fact that they are alcoholics. And even when they are older and they're confronted with alcoholism, a lot of times they're in denial. And that's why you have programs like the JCDI. and other programs.
You mean like the
too.
other program he refused to accept and get treated for?
Yeah, and that is also
He
a
made a
symptom of
choice.
alcoholism.
He made a choice. They tried to help him way back then. He made a choice, and it's. You want to interrupt me?
No, sir.
See that? I think that's what happens.
No, sir.
In your, I'll finish. I'll speak when you get finished
Mhm.
interrupting.
I apologize.
I get this feeling in the environment you're in, you control all the situation. You're the bully. You're the one that has to have it on your terms. 56 convictions later, you're still asking for your terms. You had a chance to help yourself when this man was, your best friend was killed. And you showed how much you cared then. You didn't even pay for one dime for his restitution that you were ordered to pay. My goodness.
He was named.
God, that was terrible. That's just heartless. And here you are.
And the mother came to.
You want to continue to interrupt me, aren't you?
No, sir. I'm sorry.
The rules never, decorum, the rules of law, none of this follow you. You just want to butt into everything and control the environment. Your actions here, 56 convictions later, shout more than anything you can say.
But also point out, Judge, that all of this, what the court is referring to, other than these DWIs, are like in excess of 20 years old. 20 years ago. And when he was
You mean after he was an adult?
after he was an adult.
Okay.
That is correct.
You're supposed to leave your childish things behind when you grow up.
Yes, sir.
How old are you now?
Wait.
40. So, in the last 30 years, you've accumulated 56 convictions.
Convictions for Class C misdemeanors.
Everything. A crime. Whether it's listed in the pre-sentence report. Crimes. Including felonies.
But the
I
vast
mean, they're just not,
majority,
these aren't just unimportant felonies. This is criminal negligent homicide and illegally possessing a firearm by a convicted felon.
Yes, sir.
One's in federal court.
the vast majority of the offense that the court is, continues to talk about as far as the high number are all like traffic related offenses.
It's a
I
crime.
agree that's irresponsible, but that was also
No, it's a crime.
over 20 years ago.
It's a crime. I'm sorry. I'm just counting the ones, let's say, there's a 2014 DWI. Let's see. There's a 2012 driving while intoxicated. That says 2009 that it was disposed of 5 years later. Go figure that. And then we're talking about 96, 98, 1000, 01, the 96 criminal negligent homicide, the 02, 2002. If he's had a problem, he's been given notice there's a problem that has consequences to it because of the repeat convictions. And here he is again. And the best you can say is you're going to shrug this off of, he's just got a problem. Well, this problem he never attended to. That's you're a grown up. You're supposed to deal with it adult like. You've been placed on notice 56 convictions ago. You got a problem, and you're asking, let's address it now.
Well, I'm pointing out that since he was released 18 years ago on the federal claim, his problems have been the DWI. That's the only two problems that I see on.
Yeah, but you're shrugging off of that's no big deal. I want you know what happens here when involuntary manslaughter cases show up.
Right.
I mean, there's more weeping and crying. People just asking for divine intervention to explain how they're following the rules and somebody irresponsibly, recklessly, and selfishly kills them by irresponsible use with alcohol. It's a terrible thing here. And jurors give them 20-year sentences every time. 17 years I've been here. Every sentence, every conviction by a jury, 20-year sentences. It speaks loud. That's what the people demand. They want a safe environment, and you're unsafe.
The criminally negligent homicide dealt with
Talking about people driving and killing others when they're illegally operating a motor vehicle. That's what an intoxicated driver does. That's what he's got a problem with.
Well, the criminal negligent homicide involved a 19-year-old racing.
I'm saying, I'm sorry, he's here today for a third offensive DWI, right?
Yes, sir. But I thought.
What's your point?
Well, I thought the court was saying that the criminally negligent homicide related to alcohol, and it did not.
It's irresponsible.
Absolutely.
It's irresponsible
Absolutely.
behavior. That's his character.
Oh, I agree with that.
Anything else?
I'm looking to the program, sir. I can guarantee you that. Because I said, I sent on that word. I went a lot back then. It might not seem like to you, but I really have.
How long have you had a drinking problem?
Yes, then.
Sir?
Yes, since then, sir.
Since when?
Since 96.
30 years? You think it's about time you did something about it? I'm going to do something about it.
This program, we'll show you.
You could have walked in anywhere in the last 30 years on your own, sir. But you were placed on probation in order to do something, and you didn't do something with it. You were supposed to help yourself then, and you didn't do it, and the judge revoked you. You've had more than your fair opportunity.
It wasn't behind no alcohol, sir.
You want me to read it again? It was rehabilitation that you were supposed to attend that you didn't take, and you pleaded true to it, and he found true, and you were revoked.
Yes, sir.
It's like pulling teeth here.
You are, sir. You make very much sense. I'm just saying that you give me a chance in this JTI program. If Washington officer told me, I can believe I can get better.
Look. First time, shame on you. Second time, shame on me for you being up here again. And it's not the second time. But I'm going to give you another chance to get out and show what you're capable of with a 2.242 DWI after 56 convictions for criminal behavior. You pleaded guilty, paragraphs 1 and 2, which are which is a third degree felony for operating a motor vehicle while intoxicated. You entered that plea voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in these two cases. And I am following the agreement here. And just a second, one other thing. And see, you got Miss Wynn, your mom, writes a letter about how she needs you. Did you really? You're worried about her when you're getting a 0.242 blood alcohol level driving around? You're worried about her? No. Was she drinking with you? Were you drinking? You were out somewhere drinking while your mom was at home needing you. Is that about right? Your mother needs you at home. You're sure talking about it right now. Did you need to be sober to help her?
Yes, sir, I did.
You weren't. You made the choice to get high again, right?
I'm just asking for it. This time, can you just let me go to the program, sir? The probation people? Please.
Sir, when you, I'm going to, one more time to be better, you were revoked by your previous judge.
You'll complete this program, sir, in good fashion. I'm now 85 years, 86 years
Are you
old.
through interrupting me? Go ahead. Finish your statement.
I'm sorry, sir.
You were found guilty. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You have run out of chances. You have made bad use of these opportunities that you had in the past, sir. And you have made choices. You have shown what your character is. And now here, I think it's shameful for you to talk about how your mother needs you when she needed you when you're being arrested for 3 times the legal limit. You should have been home helping her, not using her later to try to escape responsibility. That is all. Terrible. It's terrible.
Legal matters. Attorneys are required to communicate directly with their adult clients. Harper admitted to violating the conditions of his probation by failing to submit to required drug testing. His attorney asked the court to terminate his probation, emphasizing that Harper had completed an intensive outpatient program, performed community service, maintained a strong academic record while pursuing a bachelor's degree, supported his young daughter, and worked to improve his life. Harper also expressed remorse, stating that he had matured, accepted responsibility for his past choices, and was committed to becoming a better person. The judge, however, reminded Harper that his actions were not simply mistakes, but deliberate choices, and pointed out that he had previously been warned about the consequences of violating probation. Harper's mother delivered an emotional statement, acknowledging her son's poor decisions while pleading for mercy. She described him as a caring father with great potential, shared the pain her family experienced after her brother was killed in prison, and promised to support her son in meeting every court requirement if given another opportunity.